I welcome you all to lecture number 5 of Criminal Law Basic Concepts. This is a part of Clat lecture series. I am your mentor, Shekhar Gehlot. We are discussing general exceptions which provide you freedom from any criminal culpability if you have done an harm to someone intentionally. Okay, intentionally or unintentionally, as the case may be. Now, let us proceed to another exemption or another immunity. That is the case of insanity or unsoundness of mind. That is also known as McNaughton rules and beyond infancy and intoxication. McNaughton rules is a case in which this issue was decided. Okay, this is a rule in which this case was decided. That is why it is also called McNaughton rules. So insanity, like you all understand, okay, unsoundness of mind is mental illness or challenge to the mental faculties of someone. Okay. But anyhow, let's begin with infancy. Okay, that is dealt in by section 82 to 83. Section 82 says nothing done by a child under 7 years of age is an offense. That is an absolute ban. It's an absolute statement. Absolute statement. Okay, it's not a relative statement, meaning thereby there are no if and buts in this statement. If something is done by a child who is below 7 years of age, it won't be an offense at all. Whatever he may have done, okay, whatever imaginable crime you may expect a child below 7 years to commit, he will be given a complete immunity at the law. Okay. Law provides total immunity to children under 7 years from criminal responsibility. Okay, children under 7 years are totally immune from any criminal charge. Dolly incapax in law. Dolly incapax means Dolly or Dolly incapax means incapable of committing a crime. Child under 7 years. Okay, child who is under 7 years of age is considered a dolly incapax in the law. That means whatever he has done, whatever he may have done, whatever harm may have been done by the actions of a child which is below 7 years of age, all these things shall not be considered a crime. Why? Because the law says a child below 7 years is a dolly incapax. Okay, now some of you may ask why a child below 7 years and not why a child below 5 years, okay, or child below 10 years. Now that is the law which says so, and we have to be bound by it, and definitely they are not arbitrary things. There may be some rationale behind deciding child 7 years of age to be dolly incapax. Okay. Law says this is the minimum age, okay, which is required for developing basic understanding of the act. Law says till 7 years of age, no child is presumed to have understood the consequences of his act. And now let me take you back again to the criminal law. The basic concepts, essentials, it says mens rea. Okay, essential ingredient of crime was mens rea or mens reus plus actus reus. Mens reus plus actus reus, or you say mens rea plus actus rea. That means there has to be a guilty mind along with a guilty act. Okay. Now a child who is below 7 years of age, he is not capable of understanding the true nature of his actions, what he is going to do. Okay, when a child cannot understand the true nature of his actions, we cannot say that he had a criminal intent. okay, or a mens rea or a guilty mind, because a child is not presumed to be having a mind. Okay, that is why he is called dolly in capex. Okay, so infancy is the first kind of impunity or immunity provided under part 3, sorry, chapter 3 of part E. Then section 83. Section 82 was dolly in capex. Then section 83, it says immunity to children above 7 years and below 12 years who have not attained sufficient maturity to understand the consequences of his conduct. Now, if we read the statement again, immunity to children above 7 years. Now, below 7 years is definitely absolute immunity. We don't go into the mental faculties of the child, whether child is mature enough or not. We don't go to that at all. Now, we are discussing another child who is above 7 years but who is below 12 years of age. Okay, and he has committed a crime. He will be treated as dolly in capex only in cases where it is shown that child has not attained sufficient maturity to understand the consequences of his conduct. Okay, now the law usually presumes the law will presume that a child below 12 years of age has not attained sufficient maturity. That means if a crime is committed by a child who is below 12 years of age, usually the law will be very lenient with him. The law will be very much eager to let the child go. Below 7 there is no question at all, but below 12 the law will be eager to let the child go. But if there are circumstances which go on to show that child had attained sufficient maturity to understand the consequences of his act, and child indeed acted with a mental willingness to commit a crime, then he shall not be allotted this kind of immunity and he shall be tried by the Juvenile Justice Act. Okay, so below 7 complete, 7 to 12 it depends on case to case basis. Now 12 to 18 years of age, their cases are dealt by juvenile justice courts and act. Okay. Now the third category of infants are who are aged between 12 and below 18 years of age. Now their cases are dealt by the juvenile justice committee and it will depend on the case to case basis whether the child deserves what kind of punishment. Okay, now the law has created further fourth category. Okay, earlier it was 12 to 18 years. Now it is 12 to 18 years. Their cases are dealt by Juvenile Justice Court Act. That is a true statement. But if a child, this happens This amendment means change in law. This change in the law whereby law has started treating children who are sufficiently mature but aged between 16 to 18 as an adult, okay, only after 2013 amendment. Okay, in 2013 amendment were brought after the Nirbhaya rape case in which five people had raped a girl and killed her. Okay, and one of the accused was a juvenile. He was just few days short of turning 18. Okay, he was just few days short of turning 18, but factually, because he was a child below 18, he was a child as per the law, he was treated differently, and all four people were hanged to death. But only that child was given a very lenient penalty because he was a juvenile. He was given a jail term of only 3 years. 3 years, and he was convicted for raping and killing a girl in a very unfortunate manner, in a ghastly manner, okay, in a monstrous manner. But the law was like that only, and he was not treated at, at par with the adults and was left out only after 3 years of imprisonment. There was a huge uproar that why this juvenile has been let out. Okay, in order to redress the grievances of the society, the law has been amended, and now any child who is between 16 to 18 years of age, he commits an offense. Okay, the law will decide, the Juvenile Justice Board will decide his case whether he is to be treated as a child or he has to be treated as an adult. In case the law comes to conclusion that this child ought to be treated as an adult, then he shall be treated like an adult, and all the penalties which in the law can be inflicted upon an adult could be inflicted upon him. Suppose this was the case when the Nirbhaya was raped, then definitely this child, okay, who was just few days short of shy of turning 18, he would have been treated at par with the other four accused, and definitely he would also have been hanged. Okay, but anyhow, uh, things are like it is. So there's a new change now post Nirbhaya Act. So this is the position of a child under the criminal law. Below 7 he is dole in capex. 7 to 12 depends on the case to case basis, but usually and generally he is also immune. Okay, and then 12 to 16 complete juvenile, and 16 to 18 juvenile. But if you are shown to have, if the child is shown to have sufficient mental faculties, developed mental mind, knowledge and awareness, then he could be treated just like an adult. Next is insanity, that is section 84. Okay, insanity means person who is insane. And who is a person who is insane? A person who is of unsound mind. Okay, his mind is not sound. His mental faculties are severely challenged and he could not make informed choices. Okay, when someone could not make informed choices, then he can definitely not have mens rea. Okay, and depression is not unsoundness of mind. If someone is depressed, that is called sadness of mind. Okay, but the person who is depressed still have the knowledge of what he is going to do. He still have the awareness of the consequences of his act. So if a person who is laboring under depression has a certificate of depression, he commits an offense, then he should be treated just like any other adult, and he cannot take the plea of insanity. Okay, insanity is only when your mental faculties are challenged. It is a complete immunity. Insanity is a total immunity from a crime. Whatever crime an insane person would have done, provided he is insane, okay, no fault could be found with him. The rationale is because he cannot have the necessary mens rea to commit the crime, like we discussed. Now, McNaughton's case, okay, this comes out of a McNaughton's case. In McNaughton's case, a person murdered someone and he took the plea of insanity. Now, what were the considerations before the court? Now, what were the considerations? Considerations before the court. The question was raised before the court was, what are proper questions to be submitted to jury when an insane person is charged with the commission of crime and insanity is set up as a defense? What are the questions which a judge should ask? Okay, when a person has committed an offense and person says I was insane. Okay, answer was insanity at the time of doing the act, incapable of knowing the nature of the act. Answer was if at the time of the commission of offense, when the crime was committed, if at that time the person was insane, okay, at that time the person was a person of unsound mind, then he shall be given complete immunity. Okay, now there are some kind of people. Now there's a certain kind of illness known as schizophrenia. That is a psychological illness. People who are suffering from schizophrenia, okay, they are occasionally sound and occasionally they are unsound. Okay, but there is no such defined occasion. There is no such defined occasion that someone would be unsound on that particular point of time and someone would be sound on that particular point of time. There is no clear distinction. Okay, so schizophrenic patients, they can be sound anytime and they can be unsound any point of time. Okay, so in this case, it was held that if a person has committed an offense, and if at the time of committing the offense the person was unsound, okay, person was laboring under insanity, and otherwise he is a sane mind, otherwise he is a person of sane mind, then he shall be treated as a person of unsoundness of the mind. The real test is the commission of the crime, the moment at the commission of the crime. But if suppose such kind of person, such schizophrenic person, he commits a crime when he was fully sound mind, okay, then in such case he shall be treated just like any other adult of a sound mind, and he shall be convicted. He cannot then take the plea of insanity. He cannot say that I am insane. Okay, definitely this person is insane, but insanity depends upon the commission of the offense, at what point of time the offense was committed. Now some of you may be coming up with the question that how to understand whether a schizophrenic person, okay, when he committed a crime, at the time of commission of the crime, he was insane or not. Okay, this question may be popping up in your heads. Now it all depends upon the case to case basis. The court will understand the manner of the crime committed, how much planning was involved in the crime, or was it a spontaneous crime, in what manner the crime was committed, okay, and what are the people who are aware the what they say, that whether this man looked unsound that time or not. I mean, there are so many circumstances which court will look into in order to understand that as a schizophrenic person who is occasionally of sound mind, when he committed the offense, whether he was unsound or not. Next is intoxication. Intoxication. Intoxication can be a complete immunity. Okay. Intoxication can also be a complete immunity when the crime is committed. If at the commission of the crime, when the crime was committed, the person who is accused of committing the crime was intoxicated. Okay, that person was intoxicated. That means he had taken up some stupefying circumstances, some narcotics, drugs, or some alcohol, high content of alcohol. He was laboring under such influence. Then that person enjoys a complete immunity from prosecution under the law, and that person would be let free. But 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 the rider is that the intoxication under which he was laboring at the time of commission of the offense was not a self induced. Okay, it was not a self induced intoxication. That means it's not a license to all people who take alcohol or drugs to commit any offense they want. No, it is only when they were given this intoxication, either by force, okay, against their will. Against their will means okay, they were given intoxication in three cases. Either they were intoxicated by force. Okay, someone holds someone on the gunpoint and injects him with something and then ask him to go out. Now this person is intoxicated highly because he has been intoxicated against his will. And if in such circumstance he commits an offense, okay, then that person has committed no offense at all. Either by deception. Okay, someone can be intoxicated either by deception as well. I go to a party. Okay, my friends are having a party. I go to a party. I'm a complete teetotaler. I do not take drugs. I do not alcohol or smoke or something like this. But someone has mixed some pills in my coke drink. Okay, I'm taking a cola drink, Pepsi. Someone has mixed some pills in my Pepsi. I am not even aware of. Okay, and they have mixed well with the Pepsi. They do not taste the now the Pepsi doesn't sound different, doesn't taste different. I take it and now I am intoxicated. Now, if in such intoxication I do something, okay, then I am completely immune from the action of law or unawareness. Unawareness. Okay, I take some medication. Okay, I take some medicine and I am unaware about its side effects. Okay, but the medication is such that it has intoxicated me because medicines are also having sometimes same spirits which are used in the alcohol and other stupefying drugs. Okay, so I took medication for some illness and the medication's dose is such that it intoxicates me, and in that such certain situation I go on to commit an offense. Okay, then that kind of offense will not be considered an offense at all in the law. It will be considered only an harm for which no penal action could be taken. Okay, and a person who has committed harm in such case enjoys a complete and absolute ban from prosecution. Okay, provided
It's 1 o'clock.
provided the intoxication, even if it's intoxication by force or deception or unawareness, it is it should be of such a nature, of such a level, such a high degree, that a reasonable man, in such cases, a reasonable man in such doses of intoxication would not have his mental faculties functioning at all. He will completely lose his senses and do something which he has no control over it. Okay, so intoxication should be of that level. It is not that I go to a party and my friends have mixed some amount of alcohol which is usually some amount which is non injurious. Okay, so they have mixed some amount of alcohol in my drink and then I commit an offense and I say I was intoxicated by deception. No, it depends upon the level of intoxication as well, the nature in which you have been intoxicated, along with the degree of intoxication is also relevant. Okay, if it can be shown that even after all the intoxication given to you, either under deception, force, or unawareness, whatever intoxication you were laboring under, you were still able to make an informed choice. You still had your mental faculties working. You had still a great deal of control over your body and your actions. And then you go on to commit an offense, then also there will be no immunity at all. Okay, so this immunity is a complete immunity, but in a very exceptional and a very limited manner, only and exclusively when these out of these three cases you have been intoxicated, plus the intoxication should of be such level that it takes away all your senses. You lose all your mental faculties. Okay. Intoxication caused against will and act done by such intoxicated person incapable of knowing the nature of the act. This is what we just discussed, that is called intoxicated. Intended act by intoxicated person. Intoxication by will, intending to do act and does, would be liable for if it was the intent. If there was intoxication by will, and accused must have some knowledge, as if in sober state of mind. Okay, it simply says that these are keywords. It simply states that intoxication, if done by will, okay, it simply states if you self induce yourself, if someone is voluntarily consuming alcohol or voluntarily taking some drugs, okay, and then he goes on to commit some crime, then he goes on to commit some crime and he claims the exemption of intoxication, then the crime committed by such a person shall be treated just like a crime committed by a person who is of relatively sound mind. Okay, a person who is of a sound mind, a person who has done something by his own choice. Okay, but now some of you may be having a query or a question as to what would happen to the person who has induced himself, okay, who has self intoxicated himself, but his intoxication is of such a high level that he has now lost his all senses and he commits a crime. Okay, if such is the case, if someone has induced himself so highly, someone has intoxicated, someone has taken alcohol in such high quantities that he is not capable of understanding the consequences of his act, that means he has become a partially kind of unsound person. Okay, then it depends on the case to case basis, it depends upon the medical evidence. If the medical evidence suggests that his intoxication was so high, okay, was so high that he could not have understood the consequences of his act, if the medical evidence suggests, then definitely law will hold you guilty but may treat you somehow leniently. Okay, but in case you are intoxicated by someone else, by force, by against a will or unawareness, and you commit something in such high level of intoxication, then it is a complete immunity. But if it's a self-induced immunity, sorry, self-induced intoxication, some lenient view may be taken, but still you will be held guilty as well, because that is a self-induced intoxication, and we do not reward self-induced intoxication and crimes committed after such self-intoxication. Next is consent. Okay, it also springs out of the legal maxim. It springs out from the legal maxim voluntary non-fit injuria. We discussed this maxim in the maxim class as well as in the law of torts class. It is even a defense to the law of torts. Voluntary non-fit injuria, which says voluntarily consented acts cause no damage or no injury to anyone. Okay, when you enter into a voluntary, you give a voluntary consent and you incur some harm due to that, then there is absolute, sorry, not absolute, but relative immunity. That says it depends on the case to case basis. But yes, if your case fits well, you can be given a complete pardon or immunity as well if the case is a case of consent. Okay, if the crime has occurred due to consent. It says act not intended to cause death or grievous hurt or not known to likely to any person. Any person means someone who is 18 plus, given consent implied or expressed to suffer any harm and accordingly suffers, the doer is not guilty of any offense. Okay, anyone who has given consent to some harm. Anyone who has given a consent for some harm, he suffers such harm due to consent given. This harm shall not be a crime. This is the meaning of this particular thing. But when we talk about consent, we again go back to law of tort, which says free consent means you are not minor. Okay, so in the case of this thing as well, if the consent if the consent is given by minor, then it is a no consent at all. Okay, so if some minor person gives a consent to suffer some harm, and due to the actions he suffers some harm, and later on he goes on to report, then he can definitely report. And person who has inflicted such harm upon the minor may have been after taking the consent of the minor will still remain guilty in the eyes of the law. It is important to note that immunity under Section 87 will not justify causing death or grievous bodily injury or any harm which is known to the doer to be likely. Consent may just reduce the gravity of offense and mitigate the rigors of punishment, e.g., example is unlawful games, fights with weapons, etc. Okay, it further says no one can consent to death or grievous injury. Okay, no one can give consent to death or grievous injury. Grievous injury means a harm which is very serious in nature. Like someone's hand has been cut down, someone's leg has been cut down, someone's tooth has been dislocated, someone's face has been disfigured, okay, or someone is beaten in such a manner that he stays in hospital for 20 days, 20 or more days, something like this. These things are called grievous harm. Throwing acid on someone, attacking someone with knife badly, okay. These are grievous harms, grievous hurt. So it says your consent cannot extend to causing death or grievous hurt. That yes, consent is a kind of exception, okay, but it does not extend to causing someone's death or causing someone an injury which is very serious in nature. Okay, now when we discuss a case of a cricketer. Okay, he throws a bouncer. Okay, he throws a bouncer and the bouncer hits a man and he dies. Okay, then there is a maxim which is used in such cases. The maximum voluntary non fit injuria. That he voluntarily accepted that there may be some harm, some injury to him when he is batting and playing a leather ball being thrown at him at a very high speed, then definitely there may be some injury to him. But had he consented for the death, had he consented that I may even die, there was no consent to death. Okay, but this maxim is applicable here as well. Okay, but in the case of a cricketer, the maxim, both maxims will apply, voluntary non-fit injuria as well as the exception of accident. Okay, that it was accident which was voluntarily accepted to that some accident may happen which may even result into death. Similar is the case of boxing. If you go for boxing and you are punching each other and you are hurt, then that will be a case of voluntary non-fit injury. But this consent is not a complete immunity. Okay, consent is, it is important to note that consent is not a complete immunity under section 87. It will give you only the leniency. It will just reduce the gravity of offense and mitigate the rigors of punishment. Okay. Consent for offense will only make court lenient in sentencing you. Okay, in sentencing oneself. Only court will make someone only lenient when court is sentencing someone. But it is not a license. Okay, that you will, in the name of consent, hurt each other. Okay, the examples are unlawful games, fighting with the weapons. Some unlawful games are like some people may, without the permission of the law, may set up their own unlawful boxing competition in which they are boxing with each other. Okay, which is not lawful. Okay, because they don't have permission for the boxing. So in those unlawful game of boxing, if someone is badly hurt and a complaint is lodged, then in that case, this maximum voluntary non-fit injuria will definitely come into your assistance. That yes, it was a game, though unlawful, but a consent was there. Okay, you may be sentenced lightly. You may not be sentenced just as a case in which you would have inflicted that harm yourself and consciously. Fighting with the weapons. Okay, sword fighting. People are fighting with the weapons, or people are fighting with the sticks just for the fun. Okay, but in such case, if someone is having an injury, okay, if I am having a practice match, I am a swordsman. I am a swordsman. Other one is also a swordsman. Okay, and we are practicing with each other. Okay, we are practicing with each other. That's it. This is called fencing. Okay, this game is called fencing. We are practicing with each other. It's a practice match. We both are practical and trained swordsmen. And ultimately, due to my sword, other one is killed. Somehow I made a move, and the other one is killed. Sword pierces through his chest. In such case, this maxim will not come to your rescue, because the law says whatever may be the consent, but no one can give a consent for causing death of the other person. There is no consent for causing death. So even if you people were a swordsman and you were indulging into a practice match, no one had an intention to kill or hurt someone, but somehow an injury has been caused. Okay, in such a case, definitely one would be liable, but this maxim can definitely take down your sentence, lower down the sentencing part. Okay, so next we'll begin in another class.